Hey, Bougie gang, what's going on? Happy Monday, guys. Hey, guys, what's going on? Let me fix this. Yo, this is a little too small. Okay, there we go. Hi, guys. What's going on? How's everybody doing? What's going on, y'all? Okay, happy Monday, guys. You guys asked for a Diddy update the other day, and I thought this was like right on par with like what we talk about. Y'all, Diddy got accused. He got called out. He got called out by the prosecutor. Jesus. Okay. Who? Lambo. Leave stuff alone. Y'all, excuse me for a second. It's like, sir, go have a seat, please. Just came from outside. My goodness. Anyway, okay, do y'all remember? Y'all remember this? Let me show y'all this real quick. Y'all remember this? And you were like, why are we seeing this? Do you guys, a couple of weeks ago, we were looking at this video. I had it pulled up and I was like, y'all, it's a social media campaign. We talked about this, right? Like it was obvious to me. And clearly it was obvious to the prosecutors. Let me refresh y'all's memory, okay? So this was Diddy's birthday, November 4th, and we saw all the kids, the whole what they call the dog and pony show, okay? All of the beautiful children. He's got an array of children. This man has lots of kids, right? And Chance is on the phone. Is it Chance or Chase? One of the young ladies is on the phone. Okay. The other sister, Chance. Yes, maybe it's Chance. There's the twins. There's baby girl Love. There's Quincy, not Diddy's son, but sorta. And Christian and Justin are off to the side. Okay. Okay. Hey, look at old ratchet Peter Thomas. Look at old ratchet. Look at old ratchet Peter Thomas over there talking about you will be home soon, my dude. Okay. And then so he has been called out, but let's grow.
Keep going, girl.
Happy birthday to Daddy.
Happy birthday to Daddy. Yay. Yay. Happy birthday to Daddy. Happy birthday to Daddy.
I can't wait to see y'all.
Yeah.
Can't wait to see y'all.
Happy birthday to Daddy.
Just for being strong. Thank y'all for being strong.
Not Slow Bunny. You know what? I didn't even catch on to that this morning. Hey, Slow Bunny. Wait a second, y'all. You're happy you're sitting at the jail? I don't believe that. Welcome everybody. Welcome everyone back to my channel. Thank you for coming through. Y'all, I felt like this was so appropriate because, look, some of these cases are going to be won sometimes in the court of public opinion, okay? And we know Diddy is a master at trying to work that, okay?
Thank you very much. I love y'all.
We love you more. Too. Can't wait to see you in a couple of days.
I'll see y'all in a couple of days.
Say it again. I love you, Daddy.
She eat it, yo, Pops.
Hi, we're right here.
Chance right here on the phone too. Pops.
So is it Chance?
I love eating all your cake, so you're not gonna have none left.
She's literally digging her face in it.
Yeah.
You're gonna have to buy you a new one.
Yo, she's face down in the cake right now.
Say
hey, Chance.
Say happy birthday, mommy. Happy birthday, mommy.
Love you. know.
Chance is right here too. If you can hear on the phone. One more time.
Hey, Chance.
Happy birthday.
Thank you, baby. I love you.
Love you too. Miss you. See you soon.
Okay.
I mean,
All right, sing that.
Happy birthday to Daddy.
Diddy has partied enough. We know that you have posted enough for everybody. Everybody and their mama. Okay.
Happy
Keep going.
Happy birthday to
Daddy.
Happy
Happy birthday to Daddy. Okay. You guys get the picture, right? Okay. Is everybody here? Everyone here for lunch? Guys, drop your lunches. I need to know what everybody is having for lunch. Okay. Drop your lunches in the chat. Okay. What you had or having for lunch. I know some of you guys on the left coast are probably just finishing up a good breakfast. Okay. Okay, let's get into it, guys. Diddy has asked for the third time he wants to be out on bond. Okay. And for the third time, the U.S. attorney is in opposition of it, or U.S. attorney, right? All right. So I did a search for social media because that did come up. That's one of the that's in the preliminary statement. Let me make this a little thicker. Hold on a second. Let me make this a little thicker for y'all to read along. The government respectfully submits its opposition. This is 30 pages, y'all. We're going to do our best, okay? But we're going to get the points across. But I did do a search for social media campaign. Nesto's not the only one. Yo, Nesto's not the only one trying to outsmart them folks, okay? Okay, he got called out. He got called up straight up and down in this document, okay? Girl, the government respectfully submits its opposition to defendant Sean Combs' renewed motion for bail. The defendant's motion should be denied, as two judges have already concluded based on the evidence in the record, the defendant poses a serious risk of danger and obstruction of these proceedings. In seeking a new hearing, the defendant rehashes the same arguments rejected by those two judges with claims of new evidence. But the defendant offers nothing new and material justifying a third bail hearing. In fact, the only true new relevant evidence shows that the defendant has continued to engage in a relentless course. Hold on. In a relentless, let me let this, girl. He is choosing he continues to engage in a relentless course of obstruction conduct designed to subvert the integrity of the proceedings as described in the detail below. While attempting to evade law enforcement monitoring, the defendant has, among other things, orchestrated social media campaigns that are, in other words, aimed at tainting the jury pool, made efforts to publicly leak materials he viewed as helpful to his case, and contacted witnesses through third parties. Okay? Shall I continue? For these reasons, the court should deny the defendant a new bail hearing. To the extent the court decides to reopen the bail hearing, however, the defendant's application for bail still must fail under Bail Reform Act. His motion ignores the significant evidence presented by the government at the prior hearing, showing that the defendant is a violent serial abuser who uses his vast wealth and position in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. In light of the well-documented danger posed by the defendant, the updated proposed conditions of release are woefully insufficient to assure the safety of the community and the integrity of these proceedings. Indeed, the defendant's continued obstructive conduct confirms the conclusion reached by the two other courts. No set of conditions can meet that task. The defendant's request for temporary release pursuant to 18 USC 3142I should similarly be rejected. The defendant's confinement at the Metropolitan Detention Center, Brooklyn, MDC, affords him more than adequate opportunity to prepare for trial, and his convenience does not provide a basis to reevaluate the danger to the community and the threat of the integrity of these proceedings that the defendant's release possesses. I mean, my God. Okay. My God. They're not having it. Okay. Let's see what else Diddy did. Okay. Let me just. Oh, where's, you know what? I know I should. Oh, hold on.
Right now, I'm taking over my pop's Instagram. We're gonna be posting videos by spreading, good energy and taking y'all down memory lane and all the positive things he did. So stay tuned
Sound like a social media campaign to me. Let's keep going.
and watch this. Let's go. We love you, pops. Happy birthday. What's up, y'all? It's King Kong. And right now, I'm taking over my pop's Instagram.
Hi, I'm my dad's twin. I'm taking over his Instagram because I feel like we need to put out some positive energy to remind you guys he invented the remix. Guys, he's sitting in jail right now. We want him out. We want the freak offs to continue. Guys, it's not a white party if Diddy's in jail. Okay. A party ain't a party if Diddy ain't there. Okay. He invented the white party. He invented the remix. Can you please get my dad out of jail? We can't even get to his money. Okay.
We're gonna be posting videos by spreading, good energy and taking y'all down memory lane and all the positive things he did. So stay tuned and watch this. Let's go. We love you, pops. Happy birthday.
Okay, very good. Okay, that did not work. Ooh. That looks like something copyrighted being ready to be played. Okay. Well, they are going all the way, girl. Is damn 30 years down memory lane. I know you didn't put Big Papa on here, okay? Come on now. What are y'all doing? Diddy, you need to stop. Okay. Okay, so you wanted to put up all the good things and okay. So is that Chance? Yes. Okay, there's Chance. There's Love. There's Love. There's all the kids. And then there's King who did not come back. Okay. All right, all the things. Okay, just keep that in mind, guys. He is on what they are alleging is that Sir has waged a social media campaign to keep things, to remind you guys of the special times of Bad Boy. Hold on one second, guys. Okay. They wanted to remind you guys. All right. Okay, let's get into it. So this is let's go back to the document. Or maybe I should leave this here. Let me flip. Okay. Okay, here we go. The indictment and defendant's arrest. Okay. After nearly a year-long investigation, indictment 24 CR 542 was filed September 12th. Girl, that was the day an OG was born. Okay, your hostess with the mostest. That is my birthday, September 12th. Okay, not 2024, but on a year that happened on September 12th. Okay, so Diddy, after a nearly year-long investigation, indictment 24 CR 542 was filed on September 12th, the best day of the year. charging the defendant in 3 counts of racketeering conspiracy in violation of 18 U.S. 1962. Count 1, sex trafficking in violation of 1815-91, and 2, and interstate transportation to engage in prostitution in violation of 18 USC 2421, and 2. Count 3. As alleged in count 1, the defendant participated in a racketeering conspiracy since at least 2008. Specifically, as charged in the indictment, the defendant often assisted by other members and associates of the racketeering enterprise engaged in sex trafficking and acts of violence, including kidnapping, arson, physical violence, among other crimes. Say it ain't so. As the indictment alleges, from 2008 through 2024, the defendant used force, threats of force, coercion to cause women to engage in sexual activity, which includes sex acts with male commercial sex workers that the defendant referred to as freak offs. Okay, freak offs, which sometimes lasted days, were elaborate sex performances that the defendant directed, masturbated during, and often electronically recorded. The defendant ensured that female victims participated in freak offs through coercion and violence, including by supplying female victims with controlled substances, subjecting female victims to physical, emotional, and verbal abuse, controlling female victims' careers, livelihoods, and housing, and threatening to disseminate recordings of freak offs. In connection with this conduct, count 2 charges the defendant with sex trafficking victim 1 by force, fraud, and coercion, and count 3 charges the defendant with causing the interstate transportation of others for the purpose of engaging in prostitution. The defendant was arrested on September 16th and was presented and arraigned the following day by the Honorable Robin Tarnofsky, United States Magistrate Judge. The defendant's remand. Following the defendant's arraignment, the indicted and on the indictment on September 17th, the government moved for the defendant's detention under the Bail Reform Act, see 18 USC 3142 F1A B 3142 F2A and B. Because the defendant was charged with sex trafficking, detention is presumed under the Bail Reform Act, C 18 USC. C 18 USC 3142 E3D. After hearing arraignment, Judge Tarnofsky, I might be pronouncing that wrong, so my bad, y'all, found the defendant had not rebutted the presumption in favor of detention, and there were no conditions that would reasonably assure the defendant's appearance or the safety of the community. Judge Tarnofsky emphasized that serious nature and the circumstances of the charged conduct, which largely happened behind closed doors and was therefore difficult to monitor. Judge Tarnofsky noted indications in Combs' history and characteristics that he would present a danger to the community, and dismissed as inadequate the extortions from the defendant's counsel and trust him and his client given the defendant's drug abuse and anger issues. Judge Tarnofsky highlighted that the weight of the evidence was significant given the multiple witnesses observed firsthand the defendant's witnesses observed firsthand the defendant's violence and coercion. This was filed on Friday, guys, if you're just now coming in. The defendant appealed. So Diddy has requested for the 3rd time bail, and the U.S. attorney this is the motion in opposition, which means basically they are opposing Diddy get bail? And these are the reasons why. So we're just now getting into it. One of the first allegations, as you may or may not have heard when we started, is that they believe that Diddy is over here trying to work social media through his churn to try to soften, I would say probably show a softer side of himself so that people kind of feel sorry for him and see him as a family guy and see him in a way that some people have not. And rather than see him as a bad guy, see him as a rapist and all of the things that have been alleged, what they're saying is, no. Okay. The defendant appealed Judge Chernovsky's decision to Judge Carter, to whom the case was then assigned, and the bail hearing before Judge Carter proceeded on September 18th, 2024. After a lengthy argument, Judge Carter denied the defendant's bail, finding specifically that the government had proven that the defendant is a danger regarding obstruction of justice and witness tampering by clear and convincing evidence, and that the defendant is a danger to the safety of others in the community more generally by clear and convincing evidence. Although Judge Carter did not rely on risk of flight, he noted that the bail package proposed by the defense counsel was insufficient to address the risk. Ultimately, Judge Carter found that there was no condition or combination of conditions that would reasonably assure the safety of a person in the community, or that the defendant would not obstruct justice or tamper with witnesses, and accordingly denied the defendant's bail. The defendant was remanded to MDC and a Bureau of Prisons facility, where he has remanded in pretrial custody to the present. So the applicable law is that under the Bail Reform Act, the district court has the discretion to reopen a bail hearing if information comes to light that is both new and material to the detention question. What they said in the introduction was that did not happen. There's no new tea here to support a new hearing. He's bringing the same old facts. But in fact, the new facts are from the government. This is basically what this paper is about, is that he has the churn out here. This is what they are alleging, because they're going to go into more detail, that the churn out here doing their daddy's work. Okay. And more than likely up under his request. Okay. All right. Specifically, a bail determination may be reopened before the trial if the judicial officer finds that information existing that was not known to the movant at the time of the hearing. So movant is an interested party at the time of the hearing, and that has a material bearing on the issue whether there are conditions of release that will reasonably assure the appearance of such persons as required and the safety of any other person in the community. However, a bail hearing should not be reopened on the basis of information that was available to the defendant at the time of the hearing. So I think also what they're saying is, if you had the opportunity to present it and it was available to you, then you should have taken your shot at that time. If you did not, it's almost too bad, too sad. What I'm hearing is it needs to be absolutely new and new to you. It needs to be new to you and new to us and just new, period, right? That's what I'm surmising. See United States versus Mizell. Courts in the Second Circuit have found that new and material information for Section 3142 F2B purposes consistent of something other than the defendant's own evaluation of his character or the strength of the case against him, truly changed circumstances, something unexpected or significant event. Moreover, because the Bail Reform Act states only that the hearing may be reopened if new or material information is presented, leaves the decision to reopen the hearing to the sound discretion of the district court. Therefore, even if the defendant's arguments for reopening the hearing met the standard, which they do not, girl, did Will Wooten write this? Therefore, if the defendant's argument for reopening the hearing met the standard, which they do not, this court may still decide in its discretion to not reopen. So they can reopen. Like if all of those things being said are valid, still don't have to open it. But on the strength of the instructions, you're not even meeting the instructions. Okay. So based on all of the discretionary matters, be it meeting the benchmark, not meeting the benchmark, at the end of the day, there's nothing really here to warrant a third hearing for bail. Okay. Yeah, I think his lawyer's just doing his job. He's trying to earn that money because I'm sure he's getting paid a lot. Section 3142I provides the court may permit the temporary. Do you imagine, first of all, having Nesto and Sonia for clients? Do you imagine having, I can write a check for however much I want, Diddy? You know what I'm saying? Like, girl, that's unlimited. Like, oh, well, okay, hire 5 more people. You know what I'm saying? Like, he's got enough money to say hire a team, bring in whatever temporaries you need, bring in some bring in whatever counsel you need to, hire whoever you need to, right? Section 3142 provides the court may permit a temporary release of a person in the custody of the United States Marshal or other appropriate person to the extent that the judicial officer determines such release is necessary for preparation of the person's defense or for another compelling reason. This provision has been used sparingly to permit a defendant's release where, for example, he is suffering from a terminal illness or serious injury, U.S. versus Hamilton. In considering whether release is necessary for preparation for a person's defense, the Bail Reform Act simply requires that the defendant in custody be afforded reasonable opportunity for private consultation with counsel. 18 U.S. 3142. Let's see. Okay, pretrial detention will always interfere with preparation for trial to some extent, but the Bail Reform Act clearly contemplates this problem and allows for detention to provide that the defendant is afforded reasonable opportunity for private consultation with counsel. The defendant has the burden of showing that temporary release is necessary for preparation of a person's defense. So I think we might need to go back and read what his argument was, but if he was saying that he is unable to properly prepare, that's what I'm going to guess, is that he feels like he's unable to properly prepare while he's at MDC. But what they're saying is MDC does have the proper provisions available for him to properly prepare. It might not be what he wants, but it's available, right? So B, discussion. The court should reject the defendant's attempt to reopen the bail hearing based on the same information he presented to Judge Carter. So basically they're saying, like, you're presenting the same thing again. The defendant's motion to reopen the bail hearing should be denied for the simple reason that he has not presented any information that was not known to him at the time of the bail hearing before Judge Carter. As set forth below, the defendant asserts that the court should consider new information relating to the defendant's relationship with victim 1 and his communications with various witnesses as a basis to reopen the bail hearing. But allegedly new facts are the very same arguments made by the defense counsel and rejected by the district court previously, dressed up with recently produced discovery. Oh, okay. Because those facts were well known to the defendant before any discovery production, and because the defendant relied upon them in his prior hearing, he cannot recycle them here to revisit the sound determination made by Judge Carter. that the defendant is a danger and a risk to obstruct and must be detained. Okay. Y'all, this prosecutor is not playing with him. Okay. The defendant rehashing the same old personal attacks he made against victim one before. Did I say same old? The defendant's rehashing the same personal attacks he made against victim one before Judge Carter is not new information. The defendant claims that communications between the between the defendant and victim one, which were recently produced in discovery as part of the defendant's electronic devices and accounts, constitute new material. The defendant claims that the recently produced text messages reveal a loving, at times toxic, long-term relationship between two adults who decided to mutually break up. This claim is nothing new. Defense counsel made these exact points previously and even referred to the text messages and communications at the September 17th 2024 hearing, and noting that he had looked through more text messages and emails than he cared to. Defense counsel observed this is a 10-year relationship. This sex trafficking is in a 10-year relationship. These two people were in love. That will be made abundantly clear by the way they speak to each other. By the way, other witnesses described their time together, and by the circumstances of how they broke up. They were in love, but Mr. Combs wasn't faithful. At the end of the day, there was mutual philandering, and victim number one ended up marrying the trainer. Oh, they're talking about Cassie, that Mr. Combs got for her and her and had two children, that signaled the end of the relationship. I would surmise that is Cassie, right? Miss Cassandra Ventura, right? There is nothing about the contents of the messages between the defendant and the victim that was okay. So Cassie got her lawsuit, she got her settlement, and I guess they found enough evidence to prosecute, because even with that video from CNN where he dragged her in the hotel and Los Angeles said that they could not do anything, I guess the federal government said, well, we can, okay? And we'll get him on something else. We'll just we'll get her testimony to help prosecute. That's my assumption. Furthermore, in presenting recently produced text messages, the defendant cherry picks to paint a misleading picture, ignoring numerous other messages in the record between the defendant and victim one, documenting the defendant's physical abuse of victim one and his threats to expose recordings of freak-offs. Wow. Let's see. Text message reading. You know what sick and disgusting shit I was reminded of the other day? You forcing me to blank, or you were going to leak some freak off shit. I have a black eye and a fat lip. You are sick. You are sick for thinking it's okay to do what you've done, and I still have crazy bruising. I turn my head for a second and you get fucked up and you drag me down the hall by my hair. I have bleeding cuts. You hit me in my head 2 times. When you get fucked up the wrong way, you always want to show me that you have the power and you knock me around. I'm not a rag doll. I'm someone's child. Oh, that is that's awful. Look, there's no doubt that Diddy is despicable. He's done way too much. And this is just the harvest of the seeds he planted. He planted these seeds, he's done these deeds, and he's being called to account for him. I mean, that's just it at the end of the day. He can feel whatever type of way he wants and feel like this is normal. It's not normal to do someone like that. That's not how you do. And, he's just one of these guys who's now been caught. Moreover, despite attaching lengthy text messages between the defendant and victim one on various dates between August and November 2018, the defendant omits messages produced in the same thread about the defendant's violence. And then they redacted some things. The defendant also rehashes his attacks on victim one's motives in bringing a civil lawsuit against the defendant, suggesting that victim one allegations against the defendant were merely attempts to obtain a financial windfall from Mr. Combs. Across multiple bail hearings and in the instant brief, the defendant has made clear that his litigation strategy is to personally attack victim one, stooping to any depth to attempt to undermine her credibility. Setting aside this questionable strategy, none of the information that purportedly undermines victim one's motives was unknown to the defendant at the initial bail hearing. Again, defense counsel made all of these arguments previously, and these arguments have no bearing on the question of bail. The purpose of bail motion is to determine whether there are conditions that will assure the safety of the community and the defendant's appearance in court, not to entertain the personal attacks on a statutory victim. To the extent that the defendant makes issue with victim one's credibility, a trial is an appropriate forum to address that, not the bail hearing, right? The court should reject the defendant's request to reopen bail hearing because the defendant disagrees with the government's use of the term victim. So also too, this is just my opinion. I think what they're also saying too is that he fails to kind of acknowledge what is on the table. He doesn't even want to call the victims victims. So if you don't really acknowledge that there's victims out here, if you're doing kind of like the Nesto, that don't got nothing to do with me type thing, then maybe, I don't know. Okay. I don't know. But it's interesting. Thank you, Indy. I see that. I appreciate that. Guys, are you guys with me? If you're new here, make sure to subscribe to this channel. Make sure to hit the notifications. Yeah, so he's not the defendant next accuses the government of misleading the court as to the nature of certain of the defendant's communications with another victim, victim two. The government did no such thing. The defendant's primary point is of contention appears to be the government's characterization of this individual as a victim. In quibbling about how to label victim two, an individual to whom the defendant continues to pay a significant monthly sum. Girl, footnote 2. What's footnote 2 say? Bank records show that the defendant's payments to victim 2 as recently as mid-September 2024. The government has requested and is waiting updated financial documents through the present. Okay, so they're saying that so he's quibbling over a title of whether to call this person a victim or not. But according to the government, they're pulling receipts to show that you've still been paying money to this person, maybe on some keep it on the hush. Okay, not to use a bad boy reference, but okay, Lil Kim. Okay, some hush money. Okay, maybe. Or just a payment. Okay. The defendant does not present any new information or grappling with the actual evidence. The messages and recordings between the defendant and victim 2, on which the government relied at the initial bail hearing, are clear on their face and consistent with the government's representation. So I need to find bail hearing number 2 and see if there were transcripts, because if they played it, then we got to hear about that. So there might be some transcripts. Okay, so they said that there were some recordings at the bail hearing are clear on their face and consistent with the government's representations. The defendant was leveraging significant financial benefits to cause victim two to adopt his narrative of their relationship. Whether or not the defendant agrees with the characterization of victim two as a victim for purposes of this criminal case, the communications highlighted by the government indicate that the defendant used financial coercion to attempt to feed victim to a narrative that was consistent with his defense story, a theory at odds with the contemptuous text messages sent by victim two to the defendant and others. Just threatened me about my sex tapes where I was heavily drugged and doing things he asked of me, describing victim two's sexual trauma. In light of the defendant's continuing financial support of victim two, it is not the government, but rather the defendant that is misleading the court. I wonder, well, we're not going to, I mean, we know who victim one was because it was obvious. Victim two, I don't know if that's, girl, I don't want to say any names, but is that the person from Miami? I don't know. The defendant contacts with witness demonstrate the threat he poses to the integrity of the proceedings. Okay. All right. We're just moving right along here. Witness one. So they're going to talk about witness one here. The defendant attempts to spin his contacts with witness, including witnesses served with grand jury subpoenas as evidence rebutting the government's proof of obstruction, fail in their entirety. For example, the defendants claim that the government misled the court and concealed the actual content of the communication between the defendant and a witness who was served with a grand jury subpoena June 2024. Witness one, as an initial matter, the nature and substance of the defendant's communication with witness one was known to the defendant at the time of the initial hearing. But more importantly, these contacts, including the fact that the defendant eventually deleted the messages from his phone, confirmed the government's proffer that the initial hearing to refute statements made by defense counsel. So, but more importantly, these contacts, including the fact that the defendant eventually deleted the messages from his phone, confirm the government's proffer that the initial hearing and refute statements made by defense counsel. So basically, they feel like this was almost an admission of guilt, if you will. The fact that he deleted specifically those messages. Specifically, phone records show that between the end of 2022 and 2024, witness one occasionally contacted the defendant by phone without any response from the defendant. That changed in June 2024. Witness one was served with a grand jury subpoena on June 19th, 2024, and after contacting the government, was appointed counsel June 25, 24. Beginning June 26, 24, only after witness one had been served with a grand jury subpoena and had counsel, the defendant initiated contact with witness one, which the defendant attempted to obscure by initially calling witness one's wife and communicating with witness one over VoIP service, including by text. Okay, so this is hold on. This is witness one, excuse me. Witness one was served. Okay. So basically, they're saying witness one was reaching out to Diddy from the end of 22 to January of 24. He never had anything to do with the person, didn't pick up the calls. And then now, all of a sudden, once they got served with a subpoena, then he reaches out to the witness's wife and later communicating with the witness over VoIP service. including by text and a call lasting over 7 minutes. The following day, phone records indicate that witness 1 spoke with counsel for the defendant. Even though witness 1 was represented by counsel, he and the defendant continued to directly exchange text messages, and defense counsel also spoke directly to witness 1 again July 8th, 2024, following witness 1's testimony in the grand jury on July 25th, 24. The defendant called and texted witness 1 again. The defendant repeated contact with witness 1 despite his apparent knowledge that witness 1 was represented by counsel and had received a grand jury subpoena, undermines the defense counsel's previous denials that the defendant's interference in the government's grand jury investigation, and shows that counsel cannot stop the defendant from contacting grand jury witnesses. This concern is amplified by evidence indicating that the defendant appears to have deleted his messages with witness 1. Although the phone records confirm that the defendant using a particular phone number and witness 1's exchanged multiple texts from June 2024 through August 2024, there were no such messages recovered from the defendant's cell phone associated from that number. Busted. Okay. Damn. The defendant also claims that the defendant's contacts, so this is witness 2. The defendant also claims that the defendant's contacts in September 24 with an individual represented by counsel who wanted to make a public statement were not in any way obstructive because the defendant and witness 2 were previously in frequent contact. However, the contact between the defendant and the witness 2, who were bandmates, stopped in 2024. However, the contact between the defendant and witness 2, who were bandmates, they were bandmates? The defendant? I mean, is he talking about like, girl, back in the 90s? Are we talking about that? And from the timeline and the context of the defendant's contacts with witness 2, it is clear that when the defendant reinitiated contact with witness 2 in September of 24, his purpose was to ensure witness 2 was on his side and to pressure witness 2 to make a public statement denying allegations of violence by the defendant. I wonder who that girl is. That Shine? Girl, who they talking about? The defendant reached out to witness 2 on September 11th, 2024 and sent her a copy of a lawsuit. Okay, so that wouldn't be a male ex-bandmate. Sent her a copy of the lawsuit against the defendant, in which witness 2's name was mentioned several times. The defendant then called witness 2 and they spoke for nearly 6 minutes. After reading the lawsuit, witness 2 called the defendant back at his request and they spoke for over 4 minutes. Evidently, the defendant and witness 2 discussed witness 2 drafting a statement as immediately after the call, and defendant told witness 2 in a text message, redacted. The defendant then asked witness 2 for her attorney's name. On September 11th through September 15th, the defendant and witness 2 exchanged multiple text messages and had multiple calls, at least 128 phone calls in total. Throughout these phone contacts, that girl, he must have been having a fit that he was getting ready to get arrested. Throughout these phone calls, the defendant repeatedly asked witness 2 when she planned to post her statement. Witness 2 ultimately made a statement about the lawsuit via Instagram post on September 13th. Does anyone know who that is? You said Kalina Harper? Okay. Witness 2 ultimately made a statement about the lawsuit on Instagram post on September 13th, 2024. Then, after the defendant was in custody, BOP investigators recovered the following notes from the defendant's cell during a pre-planned nationwide sweep of BOP facilities. So let's read that again. Then, after the defendant was in custody, BOP, Bureau of Prisons, investigators recovered the following notes from the defendant's cell during a pre-planned nationwide sweep. So they went through and jacked his notes. Let's see. So footnote 4, with respect to materials received from the BOP that included possibly privileged materials, such as the notes recovered from the defendant's cell, the prosecution team only accessed those materials after they had been reviewed by the filter team. I guess the filter team would make the determination if that was like a note to his lawyer or something like that, something that's not, for discovery potentially, and something that's private for him and his attorney. Let's see, discussing the potential options, including the government filter team for review of potentially privileged search warrant materials. Okay, let's go back. Okay. Where did I leave off? My God, it's so much information on here from. Okay, there it is. Okay, defendant's cell, the pre-planned. So they planned on sweeping MDC, and he just happened to get some of his private messages or some of his writings in his cell taken. Okay. The strong interference to be drawn from the defendant's communication with witness 2 and his personal notes is that the defendant paid witness 2 after she posted the statement. From the timeline, the content, and the context of the communications. Girl, hold just a second. Let me check my. Let's see. Nothing important. Girl, now that Thanksgiving is getting ready to come, I mean, are you guys getting texted off the hook by everybody to come spend some money? Okay. From the timeline, the context of the content and the context of the communications between the defendant and witness 2, the defendant's clear goal was for witness 2 to draft and post a statement even after the defendant knew that witness 2 had counsel. He continued to reach out to her directly, the fact that clearly concerned Judge Carter, and rightfully so, that the defendant had multiple phone contacts with witness 2 up to and including March 2024. Changes nothing about the damning timeline and content of the calls of September 24. These communications are another example of the defendant using manipulation, influence, and power to persuade witnesses to support him. So Kalina Harper, let me look her up on Instagram real quick. Do you know what her name is on Instagram? Is it just Kalina Harper? Let's see. It's no point in deleting anything, guys, because if you delete stuff, they still gonna be able to capture it. There's no. Do you guys know what her? Let me see. Let me just search Google. Kalina Harper. Okay. What did Kalina Harper write in response to Dawn Richards' lawsuit? Okay, let's see. Let's see. I guess that maybe they're gonna put it on here. Let's see. Diddy allegedly. Okay, so dirty money. Okay, let's see. Oh, I remember. So she was in opposition. Let's see. Oops. Okay, hold on. Oops, investigators allegedly found a note in Diddy's cell. Girl, they're posting this on when did they post this on Neighborhood Talk or Shade Room? Okay, so Neighborhood Talk. When did they post this? Let's see. Girl, Diddy looking real sad. Looking real sad, and he's looking real mad. Gosh, they post so much, it's hard to find the actual. Okay, this was posted a day ago. Federal prosecutors dropped a bombshell late Friday accusing Sean Combs of pulling jailhouse moves to sway witnesses' testimony. Okay, well, we're in the middle of reading this now. This is what the Neighborhood Talk posted. But I'm sure they're reading the same document that we're reading right now. Okay. Okay, we'll go back to read this after we're finished with this. Okay. Okay. Everyone's getting through this same document. It's damn 30 pages, y'all. This is not, girl, my mouth is getting dry. Okay. Let's go to the next page. All right. Based on the foregoing, the defendant has not demonstrated that he is entitled to reopen the bail, back to the bail hearing. Okay. That he's not entitled to reopen the bail hearing under 18 USC 3142 F2B, and the law cited by the defendant provides him no support otherwise. The defendant's reliance on the United States versus English is misleading. The citation by the defendant's suggestion that when cases are reassigned to new judges, the court should review the record de novo when considering bail motions. The Second Circuit's holding was not that broad. In English, the Second Circuit held district courts judge before whom a bail motion was properly made should consider the subsection factors and make the determinations required by 3142, emphasis added. Thus, the inquiry is two-step. First, the court must determine whether the bail motion is properly before it pursuant to 18 US 3142. So basically they're saying it's a two-prong approach, one of which is it qualified? Is it properly sitting in front of the court pursuant to this bit of law, 18 US 3142? And two, if only if the court finds in the affirmative that should that court consider 3142 factors. Here, because the defendant has not satisfied number one, okay, the court need not even consider. So it's like, it's a moot point. It's irrelevant. It's a two-prong approach. He hasn't met the threshold of one. So two doesn't even come into play because he has not, number one is not, he doesn't pass the threshold of number one. The cases cited by the defendant to support his contention that this court has inherent authority to reopen the bail hearing are equally misleading. So, and they reference a couple cases. Those cases involve a district court reconsidering its own bail decisions. The Second Circuit is explicitly held that, as is the case here, when two judges of the court have original jurisdiction over the defendant's offenses, neither is authorized to review a detention order issued by the other. Okay? Okay, I can't check it. If I check it right now, I got to stop what I'm doing. So if it's when I get time, as in later after I'm done, okay, no problem. I'm not barely reading the chat right now because, girl, I still got 17 pages. Oh no, we're actually at set page 17. So we have 13 more pages. The defendant cannot rely on section 3142 for his release. Alternatively, the defendant moves for a pretrial release under 18 USC 3142, claiming the defendant cannot adequately prepare his defense at the MDC. Y'all, if it wasn't Kamala and everybody texting, it's like we got a week from all of this stuff, and now it's like damn texting everything. Didn't he call someone? I think he's talking about Kalina Harper, possibly. I don't know. They said that there was like 140 some calls. Okay, let me get back off of this chat. You guys talk to each other. Well, what time is it? Tuesday. Okay. Okay. Let's see. The law does not support the defendant's release under this provision either. It, as the defendant has amply been afforded reasonable opportunity for private consultation of counsel. Basically, what they're saying is, I'm assuming, because I didn't read that brief for the third bail hearing. Based on his answers, it sounds like Diddy is trying to run with he is not able to adequately prepare for his defense at his current location, and that's why he needs to get out. And what they're saying is they can't trust that if he gets out, he's not going to try to coerce the witnesses, the victims, and or also this social media campaign that he feels like his family is helping him engage in, because that's just what they're witnessing. First, the MDC. So now they're going to go into why MDC is adequate. So his argument is not valid because, first, the MDC has provided the defendant with more than reasonable accommodations to meet with counsel. The defendant is permitted to meet with counsel 7 days a week and regularly has access to a separate conference room off the common area of his unit. In fact, records indicate that the defendant has met with defense counsel most days since he has been in custody. Records also indicate that the defendant frequently communicates with his attorney by phone and written communications, including, as explained below, through unauthorized means. What? Hold the phone. Records also indicate that the defendant frequently communicates with his attorneys by telephone and written communication, including, as explained below, through unauthorized means. I feel like I heard something about this weekend, that maybe, you know how they use someone else's account? Maybe he's been swapping his time, or switching pins or whatever, calling on someone else's line. Okay, let's talk about it. But even if the defendant were only using authorized channels of communication, so it's either a burner phone or he's swapping phones, the MDC procedures do not infringe on a defendant's constitutional right to effective counsel or to participate in his defense. Okay, let's see. Detention. Okay, so let's okay, see United States versus El Hajj, holding pretrial detention conditions, which include solitary confinement, restricted phone access, and a chair to review discovery more comfortably, were reasonably related to the defendant's specific security concerns and did not impermissibly infringe on the defendant's ability to prepare his own defense. United States versus Muhammad, United States versus Hashimi, United States versus Kassir. Second defense counsel's proposal that the defendant must be released in order to prepare his defense is inconsistent with the Bail Reform Act, which contemplates that courts will weigh dangerousness and risk of flight against the defendant's opportunity to prepare for trial. In this case, the significant danger that the defendant poses weighed against the opportunities the MDC has provided the defendant to meet privately with his attorneys, clearly counsels in favor of the defendant's continued detention. See Argavaz 2010 WL 283064. Pretrial detention will always interfere with the preparation for trial to some extent, but the Bail Reform Act clearly contemplates this problem and allows for detention, provided that the defendant is afforded reasonable opportunity for private consultation and counsel, which they're stating that that's the case. Third, Voluminous discovery alone is not the basis for release under either the Bail Reform Act or the Sixth Amendment. The defendant does not point to any case law suggesting that the discovery of that kind produced in this case requires the defendant's release, nor can he. Oops. The defendant does not point to any case law suggesting that discovery of the kind produced in his case requires the defendant's release, nor can he. Okay. Wow. Um, C. Dupree 833 F maybe supplement 2D at 249. While this fraud case may in fact be complicated and require a defendant to review hundreds, if not thousands, of documents and meet with his lawyer for dozens of hours, the fact standing alone simply does not justify the defendant's release. Indeed, accepting such an argument would remain that the more complicated the crime, the more likely the defendant should be released prior to trial. This is clearly an absurd result. The Bail Reform Act does not mandate that the defendant's release, even if review of discovery would be more convenient outside of MDC. They're not going for it. The defendant's complaint that he still does not have a laptop is overstated. He sounds like Sarah Boone. The defendant's complaint that he still does not have a laptop is overstated. At defense counsel's request, the government prioritized production of the defendant's electronic devices, which the defendant is not entitled to keep at the MDC due to their designation as attorney possession only. The bulk of the materials the defendant is entitled to keep at MDC were only produced recently, and immediately following the production of these materials, the government began preloading the defendant's laptop and expects to provide a laptop to defense counsel in short order. Okay? He's going to get a preloaded laptop with his discovery on it, kind of like Sarah Boone. And that's it. He probably is not going to have access to internet, so he'll probably complain about that. But they can't trust him with internet because they know how he likes to email and text people. So Diddy needs to stop. Diddy has been having his way for over 30 years. And even back, let's just go all the way back. If you know Diddy's story, Diddy said he started making his money first when he had some paper routes. We're going back to the paper routes. And he tells this story about how he had a paper route and he decided that he was going to get several routes, and then he hired friends to do his work. Okay. So going all the way back, Diddy has been figuring out ways to finesse. So he figured out ways early to be an entrepreneur, but he didn't necessarily, in my opinion, use his entrepreneurial acumen or prowess, if you will, for good. He kind of is a user. And I mean, he's paid his way, I'm assuming, but he pays people to do his dirty work. Okay. That's, if you want to just like say it how it is on today as a 50-some-year-old man, I would say that the assumption is what this document is reading, that he pays people to do his dirty work. Okay. He don't mind paying for it. Moreover, the aggressive trial schedule was specifically requested by the defendant. And if he needs more time to review discovery, he can request an adjournment of the trial date. Okay. If you need more time, we can push it back because we got time. Finally, the defendant's complaints about conditions at MDC come as a surprise to the government, given the contrary public statements made by the defense counsel and statements made by the defendant in monitored calls. Now, someone asked me the other day, like, are we able to get calls? Have I asked phone calls from prison to get Diddy's calls? Have I looked into the calls? I have not. My assumption is based on the fact that you can't even, there's not even cameras in the courtroom. My assumption is they're not releasing inmate calls. There's no cameras even in the courtroom. So, I mean, it's worth an ask. There's nothing wrong with asking. But what I'm going to say is I'd be surprised. So footnote 6 is that Sean Diddy Combs' attorney says foods probably the roughest part of the mogul's life in prison. That's a People magazine, October 10th, 2024 article. Oh, okay. And then okay, so according to his attorney, he says that the food is probably the roughest part of the mogul's life in prison. Okay. Also stating um from a call from 7:20 to 8:16 on October 27th, a call in which the defendant describes MDC. Is this still footnote 6? I wonder where we can get. It looks like it was C, also F. See exhibit F. Are there exhibits attached to this? Oh, hold on. Exhibit. I don't know. We'll have to find it. We'll figure it out at some point. Okay, so they're citing some calls there. So they are actively listening to his phone calls. Okay. They're active. So you see October 27th call in which defendant describes MDC as maybe it was okay. Who knows? All right. Finally, the defendant's complaints about the condition at MDC come as a surprise to the government, given the contrary public statements made by defense counsel and statements made by the defendant in monitored phone calls. Additionally, the defense counsel has made no attempt to confer with the government about their concerns. Nonetheless, the government stands ready to engage with defense counsel on these issues if needed. The defendant possesses a serious risk of obstruction of justice. Okay, for reasons discussed above, the defendant has not met the burden of demonstrating that he is entitled to a hearing. According to the court, accordingly, the court need not make a determination regarding the defendant's risk of flight or dangerousness. However, even if the court were to analyze the factors in 18 USC 3142G, again, the court should continue the defendant's pretrial detention because no condition or combination of conditions can assure the defendant's appearance and safety of the community, nor can conditions prevent the defendant's continued obstructive efforts. The incorporated submission and arguments presented to Judge Tarnofsky and Judge Carter amply support those findings. See Exhibit A and B, and as described before, and as described further below, the arguments for detention has only gotten stronger. Okay. The defendant has continued his efforts to obstruct justice. So this is number 7. And it says footnote 7. So let's read the footnote first. Since the defendant's arrest, the government has continued investigating the defendant's obstructive conduct and began receiving recordings that the defendant's BOP calls in October 24. These calls are in their entirety will be produced to the defendant through a filter team prior to the bail hearing scheduled November 22nd, 2024. The government did not previously disclose these recordings due to its ongoing investigation, but is doing so now given the recent escalation in the defendant's effort to influence the jury pool in his criminal case set out in detail below. Okay. Is there anything in addition to? Okay, so that's footnote 7. So the defendant has continued his efforts to obstruct justice. As noted above, the evidence presented to Judge Tarnofsky and Carter amply support their findings that the defendant's posed a risk of obstruction justifying pretrial detention and would be sufficient for this court to find the same. However, to the extent that there was any doubt about the defendant's risk of obstruction at the time of the prior bail hearings, such doubt is now non-existent. Since the defendant has been detained at MDC, he has continued to try to evade law enforcement monitoring, corruptly influence witness testimony, and further attack the integrity of these proceedings. Specifically, while in custody at MDC, the defendant has repeatedly communicated with others in ways that violate BOP rules and are designed to evade BOP and the law enforcement monitoring, including as described below, using PAC numbers belonging to other inmates to make calls, using three-way calls to contact other individuals. Diddy, including individuals who are not on his approved contact list, and using an unauthorized third-party communication system to send messages to numerous individuals, including unauthorized contacts. Baby, let's read the footnote. When an inmate enters federal custody, he is generally permitted to communicate with out of custody individuals, including friends and family members, right? See generally, that website. To do so, inmates provide a contact list, which includes the individual names, phone numbers, and email addresses. So like Pen Pal 50, Mai Tai, India, not India, Bougie Gang, okay? Bougie Gang at large, okay? But he's contacting people outside that list. BOP staff must approve the individuals on the contact list, and inmates are not authorized to contact individuals who are not on the contact list. Additionally, phone calls and emails to non-attorneys are monitored by BOP to ensure that the messages do not jeopardize the public or the safety, security, and orderly operation of the facility. When inmates make telephone calls, they are required to use a PAC number. That is your phone access code that is connected to their unique BOP register number. Inmates access email using the TrueLinks system, which is operated by a company called CoreLinks. Y'all, these are all companies. If you're looking for investments, see if these companies are public. And if you want to look where to put some money, baby, it's in this penitentiary, this penal system, these phone companies, because people are using these things like crazy. And I'm sure these investments are probably very good. Okay. You're getting all the company names right here. Global Tel Link, girl, come on now. TrueLinks is a fee-based system that inmates pay for to send and receive emails using TrueLink computer system. Okay. All right. That's footnote. Okay. That's footnote number 8. Other inmates' PACs. The government has received dozens of recordings of BOP jail calls in which the defendant uses telephone accounts of at least 8 other inmates, which is against BOP regulations, seemingly to avoid law enforcement monitoring. The defendant uses other inmates' PAC numbers to make phone calls to both individuals on the defendant's approved contact list, as well as other individuals who are not on the approved contact list. I would be so embarrassed. To obtain or maintain access to other inmates' PAC numbers, the defendant directs others to pay the inmates. Baby, put money on their books, including through payment processing apps and BOP commissary account deposits. The defendant knows this is against regulations. At the outset of each telephone call, the inmate is prompted to enter his PAC number, after which an automated recording announces sharing of PAC numbers is against BOP policy and is subject to disciplinary action. Baby Diddy, you are busted, sir. Would you stop it? Sir, would you stop? Stop it. Y'all, okay, I have to check the time. Okay, we're going to get through this. We're going to get through it, y'all. The defendant also frequently instructs individual whom he contacts by phone, including family members and his attorneys, to add other individuals via three-way call. Girl, he sounds like a whole bugaboo. This practice is not authorized by BOP as it conceals the identities of the contacted individuals. The government has reviewed multiple calls in which the defendant has instructed others to dial in third parties, including members and associates of the enterprise and individuals who are not on the defendant's contact list. Okay. Non-authorized messaging services. They're like, since you want to get out of jail so bad, we are getting ready to drag you on a Friday afternoon. Okay. This was a whole drag. And I hate I missed it on Friday, but I saw it yesterday and I was like, what? Okay. In addition to flouting BOP rules regarding phone use, the defendant also uses non-authorized third-party messagings called Contact Me ASAP to obscure his communications. The defendant appears to be using two Contact Me ASAP accounts. First, and he wants a laptop. First, the defendant's BOP contact list includes a particular email address, email 1, assigned to the defendant's son, which does not appear to be owned by the defendant's son. So he's got something that says is Justin's or Christian's or Quincy's, but it really belongs to Pookie. Okay? That's what I'm getting. All right. Second, the defendant appears to be using another inmate's Contact Me ASAP account, primarily using email 1. The defendant has exchanged hundreds of text messages via Contact Me ASAP with dozens of individuals, including attorneys, individuals that are not on the defendant's contact list. What this said to the world, Portia, hush. What this said to the world, to me, is that if you are over here playing around with Diddy on these phones and text messages, this is your warning to stop, because they know everything that's going on. They probably know everything about his poop. They know when he pees. They know everything. They know everything that's going on. Don't, like, whatever is going on with other inmates, trust and believe at MDC, they are all up in Diddy's business. And this is your final warning. He knows he's breaking rules, but if you're doing this for him, you're going to be breaking the law. So unless he wants to drag other people down with him, to me, this is a very huge, you've been warned. Leave that man alone. If you're not on his list, then you're not supposed to be talking to him. Mail him a letter. Okay. The defendant's repeated circumvention of BOP regulations started almost immediately after arriving at MDC. Speaks volumes about his ability to comply with any conditions of release. Oh, because you can't even follow directions in jail. How do we expect you to follow outside? Even more concerning, however, like, sir, you're not getting out. Like, this is, I mean, I'm not a professional on some, I'm not an attorney, but on top of not qualifying for a new hearing, they have laid you to rest on terms of this. You're not getting out before trial, sir. This is embarrassing. This is very much giving embarrassing. Okay. Even more concerning, however, it's the defendant's use of the unauthorized methods of communication to continue his efforts to obstruct and subvert this criminal proceeding. The defendant's intentions are reflected in his own words on BOP calls with the network of family members and associates whom the defendant has tasked with executing his will. On multiple calls, after using the PAC numbers of other inmates, the defendant is explicit about his intention to use public statements to alter the public's perception. And if you see these black marks, it's redacted. Okay. The defendant leaves no doubt that the narrative he wants to blank is the potential jury pool's perception of his criminal proceedings. Example of these efforts are plentiful, and they've obstructed probably maybe some of the most egregious. At 2:45, 3:30, notably, the defendant continued his efforts after court's October 25th requested by the defense prohibiting this sort of conduct. After the court entered an order, the defendant enlisted family members to plan and execute a social media campaign around the defendant's birthday, and the intention of influencing the potential jury in his commercial proceedings at the defendant's carefully curated direction. So let me just say this, because maybe they're about to say it. They're on the phone with dad. All the kids are singing happy birthday. They've got Chance, which I would imagine Chance is on his phone call list. But even them putting the two phones together, even though that's his daughter and she's on the list, I'm assuming that's a violation. If he wants to talk to her, he should be talking to her on a call. Okay. You can't really prevent people from being around and people putting you on a speakerphone and you're with someone, and all of the kids, I'm sure, are on his list. But let's see. After court entered the order, the defendant enlisted family members to plan and execute a social media campaign around the defendant's birthday. Let me pull this up. You guys, we saw this and we peeped this a mile away. Okay. With the intention of influencing a potential jury in his criminal proceedings. At the defendant's carefully curated direction, the defendant's children posted a video of their respective social media accounts showing the defendant's children gathered to celebrate the defendant's birthday. The defendant from within MDC then monitored the analytics. Okay, the defendant from within MDC then monitored the analytics, i.e. audience engagement, and explicitly discussed with his family how to ensure that the video had his desired effects on potential jury members in this case. So even this little cute post being extra cute and everything, this was carefully orchestrated to play with y'all in your faces, okay? Besides flagrantly violating the court's October 25th order prohibiting this kind of influence with a fair trial, the defendant's own words make clear that his intent is to improperly influence the jury pool in his criminal proceedings. Okay. The defendant does not stop there. During other calls, the defendant makes clear his intention to anonymously publish information that he thinks will help his defense in his case. He sounds like Nesto. The defendant's efforts to anonymously leak video favorable to his defense in his case show that he is using his so-called public relations strategy to influence his criminal case. The defendant's efforts to obstruct the integrity of the proceedings. Okay. Where'd I leave off? Also include relentless efforts to contact potential witnesses, including victims of his abuse who could provide powerful testimony against him. Example, October 4th, in a call involving the defendant and one of his adult sons. The defendant says, girl, let me show you. This is what the defendant said. Girl blank. We're never going to be able to see these calls because there's no cameras in the damn courtroom. Okay. Provides the clear inference that the defendant's goal is to blackmail victims and witnesses either into silence or providing testimony helpful to the defense. The defendant is a danger to others, in addition to failing to meaningfully contend with the ongoing risk of obstruction. Guys, put in the chat right now, is this going to be denied? Or is he going to get a hearing, or is he going to be denied? It's not even worth a hearing, right? Is he going to be denied at the hearing, or is he going to be denied on face? Okay. And what I mean by on face, just basically based on his request and based on the opposition motion, the motion in opposition of his request. Number one, just from a law perspective, he doesn't qualify. But then on top of all of that, since he wanted to go there, they are dropping all of his poor and absolutely out of line conduct since he's been in detention. Girl, this is embarrassing. This is really like embarrassing. Okay. In addition to failing to meaningfully contend with the ongoing risk of obstruction the defendant poses, he also spends no time addressing the significant acts of physical violence that the government highlighted at the initial hearing, which led Judge Carter to conclude that the defendant is a danger. So he never really addresses, like, I'm going to take some anger management. I'm very sorry that, people had these experiences with me, but I'm doing my best to blase, blase, blah. He doesn't even address them. In a danger to the safety of others and the community more generally by clear and convincing evidence. Indeed, as a record before the court makes clear, the defendant's long history of violence demonstrates his dangerousness. Moreover, contrary to the defendant's claim that the evidence is thin, evidence supporting the defendant's long history of abuse, including witness testimony, communications, photographs, videos, police reports, and other material, demonstrates the strength of the government's case against the defendant, a factor considered by the court under 18 U.S.C. 3142 G2. As charged in the indictment, the defendant has engaged in physical, sexual, emotional abuse of his romantic partners for years. The defendant also engaged in acts of violence directed towards his employees and others, including kidnapping, arson, physical violence, such as throwing objects at people, throwing people to the ground, and hitting, kicking, dragging, choking, stomping, and shoving others. Multiple witnesses include the defendant's employees and others observed experiencing the defendant's violence firsthand. The defendant's acts of violence show there is no condition or combination of conditions that will adequately safeguard others and the community. The danger, I think, is quite serious. There have been weapons around. There has been significant violence, and also think it's significant that there has, I think, been a proffer of significant evidence of coercion of witnesses. Okay. I also find that the government has proven that the defendant is a danger to the safety of others in the community, or more generally by clear and convincing evidence. While far from the only example, the video on March 2016 incident at the Intercontinental Hotel, discussed at length in both previous hearings, puts defendant's dangerousness on display. Although defense counsel conceded that the incident was relevant to Judge Carter's determination of dangerousness, the defendant fails to address it with respect to the present motion. Instead, he repeats his prior characterizations of the defendant's relationship with victim one as complex and at times toxic, and pivots to the defendant's philanthropic endeavors and family relationships in effort to distract. Baby, they got the recipe, they got the blueprint on Diddy's way of trying to defend himself, and they say no go. Okay, they say it's a distraction. But the defendant's personal relationships and charity work does not neutralize or erase the video evidence showing the defendant punching the female victim, dragging her, throwing a vase at her, and kicking her. In sum, the defendant cannot walk away from a clear record in this case. His inability to explain away his long history of violence, including March 2016 incident captured on film, is a fatal blow to his application for release. Girl, application denied. The defendant's extensive history of violence makes him a danger to those around him, and safety of the community cannot be ensured short of his continued detention. Period. The defendant continues to pose a risk in flight. The defendant has not rebutted the presumption that there are more conditions to ensure his future appearance, given the fact that the defendant faces a mandatory minimum sentence of 15 years of imprisonment and a statutory minimum sentence of life in prison. In this case, the defendant has incentive to flee. Given the potential punishment and the nature of the evidence that will be presented at trial, he has nearly limitless resources to facilitate. Yeah, every time he presents a bail package, it just demonstrates to even, I'm sure, the judges who are paid well, these lawyers who may be paid well, to everyone, that this man has lots of money. His money has money. His money has money on money on money on resources on money. Okay. And he has contacts who have money on money on money. And if you're spending life in prison, he might want to take a cocktail. You know what I'm saying? He might want to take a chance. He might say, I'll give you $10 million to fly me somewhere. Who knows? All right. The defendant's new proposed bail package is insufficient. Okay. In the face of the significant evidence that the defendant poses at risk of obstruction, a danger to the community, a risk of non-appearance, the defendant's proposed updated bail package is woefully insufficient. As discussed, the defendant has shown repeatedly, even while in custody, that he will flagrantly and repeatedly flout rules in order to improperly impact the outcome of this case. The defendant has shown, in other words, that he cannot be trusted to abide by rules and conditions. While the proposed conditions suggest that the defendant will have no access to telephones or internet except calls with counsel, this is insufficient to ensure that the defendant will cease engaging in unauthorized, inappropriate communication through third parties, because damn it, he's doing it at the jail. The defendant is already doing just that at against BOP regulations. If the defendant cannot abide by rules, highly restrictive setting of MDC, there is no reason that he should be trusted to abide by the court's condition in a less restrictive setting. Okay. Okay, yeah, we talked about that, India. I don't think I mean, look at it. It's very restrictive in federal. I don't know if they can get it good. We'll listen to it. Okay. But I don't think so. Initially arrested, would they have access to his phone calls? She said no. Yeah, and the way this is going down, I don't this is they're keeping such a close eye on him. This is not going to be out for public consumption. Maybe one day, but it's not going to be 2 day. You know what I'm saying? Um, they don't even have cameras in the courtroom. So you already know, like there's no phone calls. I mean, there's phone calls, but we can't get them. Furthermore, the defendant's proposal to restrict visitors to select family members is also insufficient. Since being in custody, the defendant has deployed family members to carry out obstructive conduct on his behalf. As evidenced in jail calls, the defendant asked family members to reach out to potential victims and witnesses, create narratives to influence the jury pool, and pursue marketing strategies to sway public opinion. The defendant's emphasis on 24/7 private security is also problematic. The defendant has demonstrated an uncanny ability to get others to do his bidding. Employees, family members, MDC inmates alike. There is no reason to believe that private security personnel would be immune. Okay. The Bail Reform Act does not permit a two-tiered bail system in which defendants of lesser means are detained pending trial, while wealthy defendants are released to self-funded private jets. What? He went there. He went there. Okay. Okay. This is not a system where the brokies have to stay back and the billionaires get to go and do what they want to do, go be by the pool and sip a cocktail waiting for the attorney to come over. This is not that. Okay. Allowing wealthy defendants to buy their way out of constructing a private jail. Okay. At any rate, not that he said at any rate, the defendant's private jail proposal at best elaborately replicates a detention facility without the confidence of security such as a facility instills. Moreover, the Second Circuit has expressly decried attempts like the defendant's to pay his way out of detention. The defendant's updated proposal simply does not alleviate the risk of danger, obstruction, and flight, particularly in light of the defendant's inability to comply with BOP regulations and his efforts to engage in obstructive behavior even while subject to monitoring at MDC. Damian Williams put his foot in that. Okay, for the reasons set forth, the defendant's renewed motion for bail should be denied. Okay. Oh, baby, if you didn't give me a like yet, just on the fact that I read those 30 pages, do I really need to ask? Okay, let me check the likes. I can't even see them. I can't even see them, guys. I don't know. What? We have almost 300 people here. Take a minute. The 100 who have not hit the like button, the thumbs up, whatever you would like to call it, go ahead and show me some love and hit the like. Okay. Let's see. My God. That was a document for that ass. Okay. My God. What time is it? 3:03? Okay. One last, let me see. I remember Quincy had his post up. Let's see if Quincy's post is still up. Is Quincy like, oh, Quincy got used by dad. Let's see. We have seen many hurtful. Okay, we saw that. That was a minute ago. Okay, this is the one that struck me. Did he edit that? Hold on a second. The past month has been devastating for our family. Many have judged both him and us based on accusations, conspiracy theories, and false narratives that have spiraled into absurdity on social media. We stand united, supporting you every step of the way. We hold on to the truth, knowing it will prevail and nothing will break the strength of our family. We miss you and we love you, Dad. Okay. They said we miss you and we love you, Dan. Daddy. We miss you. We love you. Okay. All the kids, grandma, and the little girl, baby mama. The little girl mama. Okay. We love you, Dan. We love you. Okay. Let me screenshot this one. This could be my thumbnail. Okay. This will be my little thumbnail. Look at King Combs looking like, when's the next freak off? Okay. King Combs is very sus. He's giving me very sus vibes. Okay. He just wants to get back to the next freak off. Anyway, guys, I hope you guys enjoyed this reading of You're Not Getting Out of Jail. Okay. The latest edition. Okay. Y'all, a mess. Okay. No. I'm sure the people whose accounts that they've used, they can see probably their what's it called? Oh God. So the people whose first of all, it's not going to be AI. We already know this, right? We know how the using of the PAC, those PIN numbers work. If they have been depositing in other people's commissary accounts or cash apps or things like that, it's going to be a problem. It's going to be a problem. So, the kids need to this is what I think. Diddy might be mad and everything, but at the end of the day, the kids have to be strong and say, Dad, we love you. And at the end of the day, don't talk to me about your case. Don't ask me to call anybody. I just want to talk to you for 10 minutes. And if he's rejects that, then it is what it is. But if he's constantly calling people to put them in harm's way, to ask them to do things that he's not supposed to be doing, that's not cool. Anyway, guys, let me let you guys go because I have a call. Just 1 second, guys. Give me just a second. Let me put this call on hold. Okay, guys, sorry. I just got actually of all the calls. Now I'm getting one right now. Anyway, guys, you guys are awesome. Thank you so much. I appreciate y'all chilling with me for a moment. And if you've not taken a minute to go ahead and press the thumbs up, I'm asking that you do so because likes do matter. Okay. You guys have a wonderful afternoon. This was so much fun. And I will see you guys later. Bye, guys.